Right, well, we will continue now with our second workshop, everybody, and a change of emphasis now. We want to look at the legislation as it presently stands and where we consider the gaps are in there. And to lead us this afternoon until approximately 5:30, we have, I'm going to tread dangerously here, we had an eminent academic before. Now we've got an eminent businessman. So I hope I haven't offended either there. So Peter Martin is going to chair this afternoon. Now Peter started his career, this is quite a fascinating little background. Peter started his career building oil and gas platforms, laying marine pipelines in the oceans around the world. He was involved in projects in Southeast Asia, in the North Sea, in the Gulf of Mexico, in Brazil, and the northwest shelf of our country, Australia. After 15 years, he moved into the finance industry, establishing Rothschild's Australia's private equity business, and subsequently became Chief Executive Officer of Rothschild's Australia Asset Management. He was a director of a number of Rothschild's boards in Australia for over 12 years. He has an interest in several emerging companies, presently farms down in the Southern Highlands, and obviously has a great interest in the subject we have today. Mr. Martin holds an MBA from Harvard and a Bachelor of Civil Engineering from Monash University. Thank you, Peter.
Thanks very much. Yeah, it's interesting being the non-lawyer amongst lawyers talking about regulation and legislation. So I come at this from a purely tradesman-like perspective. I'd like to first, before I make some opening remarks, I'd like to introduce my esteemed colleagues. And by the way, I'm not eminent as much as that was the description, but we have a few eminent people here. On my right, the Honourable Ian Coleman, SC. Ian is a farmer from Mudgee and a former jackaroo, so that qualifies him to be up here with me. Also happens to be the Adjunct Professor of the School of Law at the University of Western Sydney, specialising in agriculture, environment and mining law. Ian was also a judge of the Family Court of Australia for 22 years, retiring last year. So if any one of you has issues, you want to get divorced, this is the guy to talk to. He returned to the Sydney Bar 12 months ago or less, and he's turned his career over to helping landowners on mining and coal seam gas issues, particularly land access, which will be a subject that we'll talk about. Ian has a Bachelor of Arts, Bachelor of Laws, Master of Arts, Master of Sustainable Agriculture, and he's a nationally accredited mediator. Simone Marsh on Ian's right. Simone's an environmental scientist who worked for over a decade, 1996 to 2007, with the Queensland Government on environmental regulation of the mining industry, including coordination of the environmental impact assessments of very major projects. She then joined an engineering consultancy as an environmental specialist. It's called Hatch and Associates. Most importantly, Simone was seconded back to the Queensland Government in 2010 to assist in the environmental impact statement assessments of the Santos LNG and Queensland Gas Company LNG projects, including drafting sections of the Coordinator General's evaluation reports. Simone made a formal complaint to the Queensland Crime and Misconduct Commission regarding the legal processes surrounding these two projects. So Simone is better known as a whistleblower, but she's a highly intelligent and capable person who watched the process and saw the flaws and blew the whistle on it. And I think it's going to be fascinating hearing her story today. She's returned to university to pursue further studies. Then on my left is Sue Higginson. Sue is the Principal Solicitor for the EDO of New South Wales, and we're delighted to have her. She has extensive experience in the legal aspects of coal seam gas and mining projects, and probably forgotten a lot more than certainly I would ever know. She was a senior solicitor at the EGO Northern Rivers office before taking up the top job, if you like. She has a Bachelor of Laws with first class honours, and she worked as a solicitor in private practice in Lismore in a number of areas, including property and criminal law. And she's also taught environmental law at Southern Cross University in Lismore. So that's the panel up here. In addition, we have a couple of very qualified lawyers in the audience, and one person in particular I'm going to be calling out for commentary, Marylou Potts, who's in the front. Marylou is a solicitor. She's got a master's degree from Sydney University in law, and she's specialised in the mining and CSG industries. I don't have her bio in front of me, so I hope I'm not shortchanging her. She has worked in government on major projects, particularly in the Northern Territory. And Marylou is supposed to be up here, but she somersaulted off a horse last week, and we're lucky to have her here at all. So I'll be tossing back and forward to Marylou, and there's one or two other specialists who are here, particularly John Nader, who was Chief Magistrate or Chief Judge in the Northern Territory Supreme Court. And John's been assisting in land access issues around New South Wales with his great deal of expertise. So we've got a fantastic body of knowledge, and of course you're out there and we'll be asking you questions, and you can ask us questions. But we'll pretty much freewheel along. A couple of introductory comments on regulation and legislation. And from the industry's perspective, when I was in the oil and gas industry, what the industry doesn't want is confusing regulation that just bogs them down, and they can't get the job done, because in the end, all of these projects are massive amounts of money. They involve huge workforces, particularly during the construction phase. And there's incredible pressure on chief executives of these companies and also project managers to get the job done, get the gas out of the ground, get it over to the LNG plant or whatever the story is. So from the point of view of the company, we shouldn't forget they want efficient and effective regulation legislation. Now, in many ways, having good legislation and even tight legislation is a lot better than having confusion, uncertainty, etc. in these areas. And I think that's what we're going to focus on today. It's all about risk management and risk mitigation. And Philip made a few comments earlier about the fact that there is no certainty what we're talking about. So how do we manage the risks that are being undertaken effectively? Now, the other side to regulation is, how do we protect both the communities and the environment from the impacts of these industries? And we're talking about in this case, one of the biggest industries in the world, if not the biggest, the oil and gas industry. This is, the next generation of fossil fuel extraction. It's extremely expensive. It's potentially extremely damaging to the environment and communities, and it rolls over the land at the speed of light. It's not like building a platform out in the Northwest Shelf, which I'm familiar with, where you've got a large conventional reservoir, you've got a fixed platform or a floating production platform, and you're banging down holes, taking the gas out, and those wells may last for 30, 40 years or longer. This is like a game of Pac-Man. It's rolling across the landscape, putting holes in as fast as you can, because as fast as you put them in, the one over there is running out. Philip mentioned lives of 10, 12 years. Some of these wells only last 12 months. The average life may be only 2 or 3 years in some of these wells. So you've got to get into your head the industrial process that the regulators are trying to control. It's like a runaway train. And that is the problem that the regulators and the politicians face with this particular industry. So it's a huge topic. There's huge volumes of legislation and regulation. I copied the regulation legislation around this industry the other night, and I haven't even got it all here, and you can see these documents. What have we seen from the coalition since they've got into government? Just quickly, to give you an idea, we've seen the strategic regional land use plans come out, which incorporates a gateway process for state significant development. And it's arguable how effective that might be, but it really hasn't been tested. We've seen an aquifer interference policy, and the guys this morning were talking about aquifer interference issues. We've got a new Office of Coal Seam Gas, we've got a Land and Water Commissioner, we've got a New South Wales Chief Scientist, we've got 2K exclusion zones, we've got industry clusters. We've got an EPA now as the lead regulator of this in New South Wales. We've got a new 40-person compliance and monitoring group. We've got a policy for CSG well integrity and CSG fracture stimulation. We've got a land access code that's mooted to go with an amendment to the Petroleum Offshore Act of 1991. We've got a Water Act of 1912, Water Management Act of 2000, Environmental Project and Assessment Act, Protection and Assessment Act of 1979. We've got licences, and we've got things called REFs, Review of Environmental Factors, and we've got environmental impact statements. I mean, this thing is massively complex and hugely, and the issue we have to address is how effective is all that? How effective is all that? Because the state government have said, hey, we've got the toughest CSG controls in Australia. And the industry is saying, well, you're tying us up in green tape and red tape, and you, the consumers, the communities, and environmentalists are saying, well, you're trashing the environment. The companies are trashing the environment, and you, the government, you're not doing enough. So that's really the issue today. So because we're very socially aware up here, we thought we'd hit the first issue I wanted to talk about. We don't want to talk about renewal of licences, because we all know ICAC just came out with a report on the inefficiencies and the problems in the process of awarding and renewing licences. So I thought I'd put that on the back burner, but it has some ramifications for what we're going to talk about down the track. The first subject, which is a hot topic, is land access. How does it work? And, let's start with, how does it work? How does a coal seam gas company get access to your property? What's the process? And really, does it work? Sue, would you like to start?
Sure. Firstly, I'd just say, welcome to my world in terms of legislation and volumes of it and regulation and all those acts that Peter mentioned in terms of what does govern all of this is some of them. That's some of the legislation. And environmental law is what we call it, and it's a layer upon layer upon layer. What deals with the component of it that deals with land access, and let's call them landholder rights, and access to landholders' property for the purpose of CSG, both exploration and production, is relegated to one component of the Petroleum Onshore Act, really. And so basically, what the law does, that one act of 1991, is it sets up a framework where companies can provide a notice to a landholder. Can be something as simple as a letter through the mail to you saying that they'd like to come onto your land and they'd like to enter into an arrangement with you so that they can undertake their exploration work. At that point, if you were to follow the legal procedures strictly as to what then can happen, is if you don't want it to happen on your land, then you say so. And then within a number of days, you can be forced to an arbitration process. And then that arbitration process is where you and the company, and the details will come out shortly, but I'm just outlining the framework. You and the company sit, and in front of an arbitrator, you say why you don't want access granted on your property, or you say how you do and how you'd like it, or the only terms upon which you would. Assuming, let's say, you don't want it and you can't reach an agreement, the arbitrator has powers to impose an arrangement, an access arrangement on you. So a legally binding agreement that grants the company access on particular terms to your land. If you don't like that, you've got a few days to get back to the arbitrator and say, well, okay, I want that amended. This is how I'd like to have it amended, and you've got a bit of a second bite at the detail. And then the final decision of the arbitrator, let's say it's an access arrangement imposed upon you, then you have an appeal right to the Land and Environment Court, and you start again with the Land and Environment Court. Arbitrators have powers to refuse, they have powers to impose. So that's basically the kind of overarching system that you might find yourself ordinarily in. From what we've learned through the practice of this, it's ordinarily where a company is absolutely dead set that your particular land is the one they need access to. Obviously, there's some companies that, for example, in the Northern Rivers, there were certainly some companies that were seeking access to land. As soon as a landholder said, no, we really don't want to do this, then the company packed up or knocked on the next door and found, realised they had a number of options that they could seek to engage with landholders. But essentially, the framework that we have is that you could find yourself, as many people are, in an arbitration without legal representation, because there is a provision in the current law that says if the company, in order to be legally represented within that arbitration, both parties have to agree to that. And the experience at the moment is that some of the companies are not agreeing to landholders having a legal representative to assist them. So you might find that you as the landholder are sitting in a room arbitrating with an extremely experienced, well-knowledged, well-qualified head of a mining or exploration, CSG exploration company. So that's the rules at the moment. So one of the things I would just briefly say about that is I think there is a broad acknowledgement on part of government, regulators, communities, lawyers, that the legislation that governs CSG at the moment never really, in 1991, the Petroleum Onshore Act, did not at that time anticipate the situation, both the industrial situation we're seeing now as well as the social situation and the legalities that we're seeing now. So there is clearly an understanding that this law, the industry is ahead, for want of better terms, ahead of the regulation and the law that governs, and arguably at the moment with with a bill before Parliament seeking to amend the legislation is a clear recognition that this legislation isn't up to the job that it's meant to be doing at the moment, but that is the legislation we have.
Ian, do you have any?
Yes, I'd certainly embrace everything Sue has said. The issue of access pursuant to an exploration licence is an incredibly complex matter, even in what appear to be relatively straightforward landholder situations. If you are a landholder, you only need to reflect on what goes on your property and the risks you face to imagine some of the things. The superficial level, between what hours of the day, on what days of the week, and in some I've seen half-day Saturday, can the explorer come onto your property and prospect, right through to issues of liability for remediation of the damage which is done. As you probably all know, pardon me, the explorer doesn't come on with a garden spade and dig a few 2-foot holes and then put the dirt back over and sprinkle some seed around and move on. It's hugely invasive, and the consequences, particularly for well-run rural enterprises, are potentially enormous. Sue has said that generally that you can only be legally represented if the explorer agrees. I'd like to think that because just hearing about Marylou Potts and my involvement in a case was enough to make them do it, but recently we had an experience where I think it's fair to say we were led to believe that the mining company would go along with our clients being legally represented. We outed ourselves, and instead of a letter from the lawyers, we got one from the environmental manager or some other very nice titled person in the mining company saying it would be better if we kept the lawyers out of it. There's a bit of a farce goes on in these situations because the lawyers are only literally kept out of the room where the arbitration is happening. Everything else is orchestrated by lawyers and done on legal advice. Even if the explorer consents to the landholder being legally representative, notwithstanding that there are some terrific lawyers and environmental consultants and other experts who are willing to put their shoulder to the wheel, it's still a very uneven contest, because doing the best one can, the landholder is, unless they're very, very well heeled, is necessarily reliant upon either pro bono legal and expert assistance, or legal and expert assistance at vastly reduced rates. There's a limit to how much of that sort of work we as lawyers can do, and as experts they are able to do, and the system really doesn't it doesn't even begin to provide a level playing field or a competition between equal teams. As Sue has said, and not surprisingly, explorers have people whose sole job is to negotiate or arbitrate access arrangements, and they, with all due respect to us lawyers, are every bit the equal, or perhaps better than lawyers, because they're doing it all the time. It's their bread and butter. So, right from the start, if you have any concept of procedural fairness, natural justice, broader concepts of justice, you become fairly nervous about this whole process. Arbitrators are expressly precluded from making costs orders in the arbitration. Going by some of the arbitrators' performances in recent times, for landholders that might be a good thing, because you get the distinct feeling that the arbitrator might, if he or she had the power to make a costs order, lump that on the landholder too, just for good measure. The arbitrators don't have to have legal qualifications. I'm not suggesting that having legal qualifications is the be-all and end-all of anything, but I kind of think that if you're exercising a quasi-judicial function which has very serious impacts on people's rights, it might not be such a bad thing if you have some qualifications in law. There's an arbitration running at the moment. It's being conducted by a Sydney Silk who is doing an impeccable job. If the arbitration were proceeding in the High Court, the parties would not be being afforded a greater measure of justice. A very interesting side effect of that is that, notwithstanding the intensity of the struggle, the landholders involved, I have no doubt, feel they are getting a fair go, and whatever the outcome, subject to some legal issues, which may result in an appeal, there is no chance, as far as I can see, that any appeal will result from any way in which anything the arbitrator does or does not do in that. Conversely, there are arbitrations where, from the very beginning, there's this incredible and palpable ramping up of the atmosphere, and I've seen firsthand in one that's currently underway just what an incredible impact the arbitrator's apparent absence of knowledge of or respect for established legal principles has had on everyone involved in it. The impact it has had on the landholders has to be experienced firsthand to be believed. It is just extraordinary. The arbitrator, I suspect, believes that he or she is doing the best that he or she can in that one, but you can't help but feel that much of what's going on could not possibly happen if someone with legal qualifications and some broader commitment to the interests of justice was in charge. I have a belief, based on 40 years as a legal practitioner, that most people can accept a bad decision, provided that it is arrived at after a process which they know and see is fair and transparent. The cornerstones of our legal system are transparency and fairness. Put simply, if you've got nothing to hide, bring the whole world into the courtroom. Let them see and hear the wheels of justice turning and the way in which they do. Sure, the wheels of justice don't necessarily take everybody to the station they wanted to go to, but they get there in a fair way. And I think this is a big part of the problems. The procedures are very loose, and I think what Sue said is absolutely right. This legislation was designed for an earlier time and without the contemplation of the complexity of issues which arise for determination. That said, I don't accept that as any excuse for the failure to afford parties procedural fairness. That extends to some very simple things like allowing people to call evidence, allowing those who don't agree with that evidence to test it in the time-honoured way of cross-examination, making submissions when all the evidence has concluded, having a transcript, pretty good way for transparency to be enhanced, both in terms of the outcome of the process and the fairness of the adjudicator. A fundamental principle of our law is that at all times a decision maker maintains impartiality and the appearance of impartiality. That concept seems to be lost on some arbitrators to the point where, before the process has even commenced, there are pronouncements from on high condemning the conduct of one party, usually the landholder. To have the temerity to suggest in those sorts of cases to the arbitrator that he or she may perhaps be manifesting signs that, in accordance with long-established legal principle, would suggest a reasonable apprehension of an absence of impartiality is almost to call in doubt their paternity or parentage. Failure to understand the difference between an allegation of actual bias and an absence of impartiality is, it seems, lost on many of these arbitrators. Under the legislation, conciliation precedes arbitration. Conciliation is supposed to be confidential, and the whole point in conciliation is you might concede things that you would not concede in arbitration or at trial. It seems rare that that's pointed out to people. Indeed, some arbitrators take the view that what happens in the conciliation is evidence in the arbitration, and what happens in the arbitration is evidence in the conciliation, and what the heck does it matter anyway? I happen to think it does matter. Reviewing a decision is a costly exercise, involves a trip to the Land Environment Court. If you are unsuccessful, unless you can establish a public interest in running the appeal, you're likely to be ordered to pay costs, and those costs are likely to be very substantial. The cases suggest that in this context, establishing public interest is more difficult than you might imagine. There are some concerning, I think, some concerning things happening, perhaps as a consequence of the fact that the legislation is, as Peter and Sue have both said, the legislation is in arrears of what's going on, and even to the point of what could perhaps best be described as open-ended access arrangements, whereby what the access arrangement actually provides depends upon what somebody yet to make a decision about something of an administrative nature, which can't be challenged, comes to decide. So you have, in effect, a delegation of what the access arrangement is to somebody whose decision you have no capacity to challenge, and that's a concern. The enforcement of the agreements is, I think, potentially problematic, given that the access arrangements determined by arbitrators provide for compensation, but in reality the landholder is put in the position where if he or she does not receive the compensation that he or she thinks is appropriate under the agreement, you potentially then have to look to where you enforce that against an opponent whose pockets are much deeper than your own. And in circumstances where the venue for doing that may be problematic.
Can you point out the provision that passes the gas to
it will be said that, and correctly, I have no doubt, that only a small number of access arrangements proceed to arbitration. But anecdotally, I know of a number of cases where that has been because the landholder was overwhelmed by the prospect of going to arbitration.
That's right.
I've tried to assist people in the course of arbitrations who at times have said, is this really going on, or should we just give in? And that's a very sad state of affairs, to think that law-abiding, decent, tax-paying citizens who care about what in many cases is their only or their major asset in this world, upon which in many instances they depend for their living, come to that point in the exercise. I think there are changes needed to the arbitration provisions. From a legislative point of view, they would be very simple to effect. Allow legal representation, provide for the rules of practice and procedure that apply in other quasi-judicial determinations to apply, give the right to cross-examine, make submissions, provide reasoned decisions, and provide an appeal process which is not potentially so overwrought with costs implications that people could, in an appropriate case, take them up. I don't think that would make life any less fraught for someone who suffers an access arrangement, but I suspect that by curing the process there would be a lot fairer, there would be fairer determinations, and landholders would be far more capable of living with them. And I think that's probably much more than anybody wanted me to say, but that's all I've got to say.
It's a fabulous assessment of the system as it exists today. I'd have to say I've been involved in 5 of these now, and Ian points out the one that has gone like clockwork, being run by senior counsel who is handled it impeccably. But the other thing that we should say is these are incredibly complex, and a senior counsel sitting beside me said, Peter, you've got to understand that some of these cases would test the full bench of the Supreme Court with all the complexities. Now, I'd like to quickly get a comment from Marylou Potts. Marylou's been involved in most of the arbitrations going on in New South Wales. Now, most of these are in the coal mining sphere, but the rules are essentially the same as the coal seam gas or the Oil and Gas Petroleum Onshore Act. And I think a couple of comments there. There's a principle that's been talked about, but about fairness and equity. Ian mentioned it. The no worse off principle, that the environment and the landholder are no worse off because the company and the government are the ones reaping the rewards. Why should the landowner bear the risks and the costs of this whole process? And that's a question I put to Marylou. Tell us about the costs that some of the landholders face and how that might work.
Do we have a microphone? One's coming, Justin. Pick the microphone.
Someone stole the hand mic.
No, it's coming. It's coming.
As a legal bench, I think we're going to slap him over the wrist.
Can you hear me?
You might have to talk up.
Probably got to turn on.
Can you hear me now? All right.
Hold it up.
If I can put it close to my... So, as Peter said, my involvement has been principally with landholders who have had coal miners seeking access to the land. I actually haven't done an arbitration with respect to coal seam gas. Nevertheless, the legislation with respect to access is almost exactly the same. Bar the provisions which actually protect the landholders, which are in the Petroleum Onshore Act, Section 71, and in the Mining Act, Section 31. And there are differences there which are actually quite significant. But I think the point that Peter was making, which I absolutely agree with, and it's a point which was made by one of the landholders involved in an access arrangement situation, and his view, and I completely agree with it, is that the landholder and the environment should be no worse off as a consequence of a prospector trying to get access to their land. And the issue, as I see it, is that they are substantially worse off, and query whether the environment will also be substantially worse off with the current legislative regime as it is monitored and regulated and administered in New South Wales today. So that's really all I have to say.
The issue of land access is really fraught, and there's a huge amount of detail behind some of the commentary that you've heard here today. We'll have to move on, but you can go. We could spend all day talking about the issues in land access, the fairness and equity, how, from both perspectives, the company perspective and the landholder. We don't have time. I mean, there are fundamental issues as to should a landholder have the right to say no. Santos have gone very public saying they won't force themselves onto any property where the landholder says, no, I don't want you. Other companies, some of which, of whom we are well aware, take the entirely opposite view and employ every mechanism they can to push their way onto properties with great consternation from the landowner. But look, moving on, I think there are so many big issues to talk about in the legislative arrangement. I thought back to the water issues, off the social landowner issues, I wanted to ask Simone, we all talk about these things called review of environmental factors and environmental impact statements. Before you are able to undertake an exploration program, you meaning the miner or the gas company has to submit a review of environmental factors. After they have their licence, they've then got to say, well, how are we going to do this in the environment of this particular area? And as we know, all areas, and as the scientists said, and I'm really upset with them because they took a lot of our firepower away. Some of the things they said about the regulations. The point being, a ref is supposed to be about looking carefully at the environment and assessing the project and saying this is all possible or these are the controls. So I'd like to turn to Simone and say, from your experience in Queensland, why don't you tell us a little bit about how that process has worked, or you've seen it work in Queensland, and then we'll talk to New South Wales.
Sure. It's extremely flawed, and it is complex, just like I've heard. It's extremely flawed, and it is extremely complex as well.
Can't hear you.
Pull it right up.
Right up? Sorry. How's that better? Yeah. What I was saying was that we have a very flawed system in Queensland, or we did when I was working in the Coordinator General's office, Department of Infrastructure and Planning in 2010. I arrived there in February of that year, seconded into the department, and when I got there, there was a row of folders that went for about 1 metre across a shelf, and that was the first of these LNG projects. It was the Santos one, and it was apparently 15,000 pages in length, and we were given a very short time frame to quickly have a look at that and then go straight into launching into meetings with the clients. My role was really to talk with the environmental regulator, which is DERM. It's changed its name, so it's basically the Environment Department, and get the comments back into the Coordinator General's office. And I started looking through the documents, and it was looking like you were going and looking for a needle in a haystack, because the information that you thought should have been in there, actually, when you looked and looked and looked and looked, wasn't there at all. I started by looking at basic things like maps of where the infrastructure was going to go, and it wasn't there, which is really strange because, for typical mining projects, you would normally understand where the activities were going to be conducted. There'd be boundaries, so you could start your assessment with a map. It's a nice way to start. So it was really frightening experience, the whole picture. But at that point, I did make my supervisors aware that they were not meeting the requirements of the Environmental Protection Act by not providing that location information. The other things that were missing from that document, very basic things, were the baseline studies that the guys were talking about earlier. There was a few desktop studies, but not a lot. Didn't really tell us very much. And there was certainly extremely limited baseline work in those documents. So the next thing I went looking for was cumulative volumes of water and cumulative volumes of salt. And it wasn't there either. So I actually had to do some of the work myself that you would have expected the proponents, consultants, engineering people to have done and put them into the document so that the public could be made aware as to, what are we looking at here? What's the cumulative impacts involved in these projects? I ended up having to coordinate with someone in Durham, Dr. Ian Wilson, and we sent emails back and forward trying to calculate these volumes. So instead of being an evaluator, you end up having to do the work yourself in a government office in a very short time frame. And it's as if the lawyers for the companies, it is as if they've gone through those documents and taken out information, because it doesn't make sense that those things are missing. Because if you go back a step, before I got there, these projects had been through two steps actually, under the State Development and Public Works Organisation Act in Queensland, which is the projects that are the significant projects for the state are brought under an assessment process, an EIS assessment, under that legislation. And if you have a look, and they're up there on the web, so go and have a look if you're interested, you'll see there are initial advice statements for those two projects, the Santos and the QGC project. And if you look at those initial advice statements, and then you look at what they really have been approved to do, you'll see that the initial advice statements don't really tell you very much at all. It really plays down the aspects of the project that you should have been told about right at the beginning. Then if you go and have a look at the terms of reference, and then refer back to these EIS documents that I was talking about that are along the shelf, you'll notice that the items that were asked for in the terms of reference, actually, many of those items do not actually come into the EIS document, so they're not there. And another way of just proving that is to simply look at the Coordinator General's evaluation report that came out at the end of this process, because the conditions that are there ask for the same information that was asked for back in the terms of reference stage. So that just demonstrates straight away that the proponents didn't provide that basic information on cumulative impacts on locations of infrastructure and baseline studies.
Can I break in there, Simone, and ask Sue a question? Coming back to New South Wales, how does that flange up with what we've seen in New South Wales, and what does this mean for the administration, monitoring and compliance that our government departments are providing? And I'll get to both to talk about that.
Well, I mean, from the perspective, obviously we talk to many people in the community that are looking at reviews of environmental factors when we're talking about CSG exploration, and the experience, probably a little bit different from those at the big project stage, but in a sense exactly the same experience is what has been lived here in New South Wales. So for example, the majority of review of environmental factor assessment documents that we looked at now, and I would say probably up to about 3 years ago, or perhaps only 2 years ago, were without a doubt some of the poorest documents that I think we as environmental lawyers, when we were looking at assessment documents, had seen perhaps ever. We were seeing documents that started off as, let's say, CSG in Gloucester, and by the time the word processing desktop exercise had finished, we were talking about CSG somewhere else, like they were really cut and paste jobs that were undertaken by different consulting firms for different proponents. And we identified that as being extremely problematic, and our office wrote to the regulator, at the time then Resources and Energy, before the Office of Coal Seam Gas, and we pasted a number of case studies where, look, I mean, really, how how are we meant to be explaining to the community what's being assessed here and what to be expected from an exploration project? And that was all very embraced by the department. It was certainly acknowledged, it was taken on. The department then issued certain guidelines, and I suppose to assist proponents in saying, look, if you are preparing a review of environmental factors, this is the base kind of document that these are the base matters you're meant to address in that ref document. And I mean, I would say our experience is, in terms of review of environmental factors documents, they are certainly a heck of a lot better than what they were 3 to 4 years ago in relation to CSG activities, without a doubt. But as I said, it did not take much to make them much better. They were really, really of an extremely poor standard. In terms of, some of the bigger projects that we've seen, the law, unfortunately, in New South Wales, whilst it sets certain standards and certain things are required to be addressed, the compliance, the legal compliance with that standard of documents is really, as long as you substantially comply with what's required as a proponent under the law in terms of an assessment document, then you're pretty much okay. You've done it. As long as you've substantially answered the questions and you've substantially complied. The law has said, and this is going back to the 80s in terms of environmental assessment documents, look, you're not really expected as a proponent to cover absolutely every single aspect of the project, which is a very, very interesting interpretation when the actual legislative provision says you must consider to the fullest extent possible the impacts on the environment. There is a subjective aspect to that, but one of our cases most recently, which was a CSG case about challenging the assessment of a review of environmental factors for a CSG exploration activity, which was the Fullerton Cove case. That case was pretty landmark because the judge in that case actually said, there is an objectivity about what is required to be assessed as part of an environmental assessment for CSG exploration. On that occasion, she determined that it was fine. The assessment that was there was fine. So it's interesting because the experience is extremely similar. I'm kind of glad I'm the lawyer that would look at the documents after and not the one that has to assess them and make the recommendation, because I think that, some of the proceedings, the court proceedings that do involve environmental assessment documents, the crew from the chambers that walk in with the trolleys of those documents, we've had cases where there's trolleys along a floor longer than this, and that's, the court documents, including the environmental impact statements. So, they can be enormous, but if you're scanning for actual, as the scientists showed, what are the impacts really going to be? What is the actual parameters of the project? It can be difficult to find.
Thanks, Sue. We'll turn over to questions in a minute. The comment I'd make, in business you call it the deal breakers. I think Philip Pell's put it very well. What are the key issues? Now, where should the focus of the environmental impact statement of the REF be if you're drilling through or into the Great Artesian Basin or some highly productive aquifer on one case, or you're on highly valued agricultural land? Where should the REF focus? And I think I'll turn the question to Simone. How many pages in the documents you looked at were related to groundwater impacts?
It's interesting about the groundwater section of the first report that we looked at, because I'm a generalist, so my role in the past has been to coordinate comments from all the specialists in the environment area. And at the stage where the Santos project was signed off, we were still actually waiting for comments from the Department of Environment, who were also in the process of seeking information from the proponents and still had not provided that back to us. So we just heard this morning, earlier today, how complex just the groundwater issue is alone. And yet, if you go and have a look at that evaluation report that was done for the Santos project, you'll note that there is only a very small section on groundwater, and that's about the government's policy on the matter. There is actually no evaluation or assessment of the material that was given to the public and to the government. yet the EIS process was ended without that assessment.
I think
Sue?
so I think in terms of really what a best kind of practice system, I suppose, looks at, and I think that's where we try to kind of dwell as public interest lawyers. Well, what does a best practice system entail, and what are in terms of an assessment? Well, you know, you do want a legal standard that is a high one. You do want the absolute transparency. I think it resonates through every aspect of law. I think that, you know, communities as well as proponents ought to feel free to understand really the real dialogue that is happening in amongst the experts in relation to the impacts of the proposals. You know, the documents get bigger and bigger, but at the end of the day, we love big documents if they're full of honest, transparent and really engaging detail that can really help communities understand what impacts are. I think the fear of having a very technocratic system where it is just administrators and experts is a system of assessment that ultimately will fail us all, the environment and the community. I think that, you know, some of the best opportunities that projects have is where you get local knowledge, input of local knowledge into those documents. So most of the EISs and refs that we see have virtually no real community consultation engaged within them. There's always a standard requirement. You must consult with the community. It tends to be, if a proponent is doing the right thing, there might be a few public meetings held, and those public meetings are just to come and tell the community what the proponent expects. But I mean, that missed opportunity, I think, is one of the real deal breakers. I think a proponent that is genuinely engaged with a community early and often is going to end up with a much better assessment and a much better environmental assessment document. Because, yeah, I mean, the people on the ground who have lived in a local area for a long time, there's evidence through the history of, since 1979, of the New South Wales planning system. The reason we introduced community participation to that legally entrenched right was because it leads to, ultimately, better decisions. So I think that from my perspective, as a lawyer who represents the community in those public interest, and we're dealing with scientists and technical information, one of the deal breakers, I think, is serious engagement and really encompassing the public participation aspect.
Well, at that point, thank you very much to our panellists, but we're going to open it up for questions. So please put up your hands. And this lady in the red.
This is the amendment for the 1990.
No, we can't hear it.
You need to be on the
For the amendment to the 1991 Act,
Yep.
Coal Mining Act. What do you think will be in that will entail? What do you think? When will it happen?
Well, so there's a bill in front of Parliament at the moment, the Petroleum Onshore Amendment Act. I mean, my understanding of this really, so it's got a number of, they were described to us recently from Office of the Department. With the acknowledgement that the legislation at the moment is not up to speed, this is a kind of half measure to try and get at least some of the base measures that ought to be in the legislation at the moment. So there's things like penalties for non-compliance of licence holders. There's things like an attempt to improve the land access arrangements situation so that, you know, the company has to pay the reasonable legal costs of landholders that have to negotiate access arrangements. There's also a few provisions that have been a bit controversial amongst the community. They're provisions that allow the minister to grant licences to third parties, particular third parties, to be able to go onto your land to either for the purpose of remediation of land where there's been damage done, but also the taking of certain samples. So there's additional powers being given to the department as the regulator, and there's a few provisions that they're trying to even up, I suppose. The Petroleum Onshore Act a little bit more in line with, say, where the New South Wales Mining Act is, which has been a much more active piece of legislation over the life of itself since the 90s than the Petroleum Onshore Act. So the argument with, or the view of the department at the moment, as I understand it, is that this is a way to try and bring it a little bit in touch, but they are certainly of the view that it's not the whole hog. So, and this bill's before Parliament at the moment, and it's been there since last year. So I don't know what will happen in the next sitting of Parliament.
Robert, thanks again. Having reviewed a few of these things, I think there was one done near Balladder, which I think was done on subcontract to Balladder Childminding Centre. Was the quality of the document, but anyway, what I have seen with some of these REFs and EISs that have been paid to review as an independent professional is there does seem to be an intent to mislead in these things, and some of the science is actually so wrong. Does make you wonder if the person doing the work is qualified to do the work, or B, if they're committing fraud by putting those thoughts forward in a document. Is there any penalty in New South Wales, Queensland, or federally for committing scientific fraud in a document such as an EIS or REF?
Yeah, I mean there's provisions in the environmental plan in New South Wales. Yep. So if it's a New South Wales application under the Environmental Planning and Assessment Act and the regulation there, it is an offence to provide false or misleading information. Whether it's an offence to be incompetent, I haven't seen an offence of that yet. So, yeah.
Simone, I think Simone can make some comments about the Queensland situation.
Yeah, sure. I'm pleased you raised that because another key problem with those EIS documents is that they're not signed off by any particular individual, and they're not peer reviewed. So they're totally flawed. Really, accepting that as some sort of scientific analysis is you can't, and the public servants are just left with this situation to deal with. So it's rather appalling, and they really should be changing the laws in every state and the Commonwealth to ensure that those documents are signed off by people who are qualified and an auditor. Yeah.
Can I just make one comment while you go into the next question, and that is there was a few years ago an amazing initiative that came, I think, from maybe a North Coast environmental organisation, and they put forward a proposal that I think might have even been adopted by one of the political parties. It's going back a little while, but it was a scheme of environmental assessment that what it was all experts and consultants belong to a register or a pool of consultants. A proponent pays a certain amount of money into a particular fund or a pool, and your environmental consultant is appointed to you as a proponent, and your contact with them is through a third party as opposed to a direct relationship, because there is this idea that, you know, is that where the system of environmental assessment is breaking down, that the proponent, someone said you'll get what someone said it earlier, I think, whoever employed you, the document will please that person. And so that was one scheme that somebody thought of and actually even got the detail of what it would look like and how to manage it. It was quite interesting.
I'd make one other comment. We shouldn't confuse environmental impact statements with the truth. What they are is a document that gets a project up and running and gets it through the bureaucratic hoops. And that's not saying that they're full of lies and everyone's a distortion of the facts. But the reality is, and another question that may be asked is, does the department or the government have the skills, the expertise, or the time to actually correctly assess these projects when there's a plethora of massive resource projects hitting the desk, and you go into some of the legislators' rooms and you see piles of documents? I don't know how they get through them. So we've got a question of administration, resourcing, qualified people like Simone, but how can Simone do this in half a day? You know, that's 6 months' work to assess what she was asked to assess in a day or two or three.
Can I make a quick comment?
Ian.
Just picking up the point from across the room, 20 years ago the Federal Court devised, or was instrumental in having devised, the Expert Code of Conduct for expert witnesses in civil proceedings, and all the Supreme Courts of the states and territory and district courts throughout the land apply that. I wouldn't have thought it would be rocket science to legislate that an expert who provides a report in support of a proposal under either of the acts be obliged, as witnesses are in the courts, to acknowledge that he or she has read the code and is bound by it. I suspect that would reduce to some extent, but not eliminate the he who pays the piper calls the tune syndrome, which prior to the introduction of the expert witness codes was a feature of expert evidence in civil and criminal courts throughout the land. So I'm not suggesting that would cure the problem, but I suspect it would go some distance towards that, because if you had sanctions attaching, then perhaps experts would be a little bit more balanced in what they put forward. But that's just a thought on that one.
Did you have any further? Okay, and next question. I think the gentleman in the middle.
Thank you very much, Rowan Beam again from Narrabri. Look, I don't want to be an alarmist, but in 6 weeks there's an EIS coming to town for the Narrabri project. Okay, so we've already heard it's going to be full of Santos speak. I think part of the reason why we're all here is because we're scared witless that this is about to hit, and we know we've got absolutely nothing that we can actually do about it, because we've just heard from you guys. There's not much we can do, so is there anything inspiring you can tell us and suggest to us as to what we actually start doing today, and so we can go home with at least some semblance of sanity, thinking at least we might be able to win this? Doesn't sound too good at this moment.
Oh gosh, look, I just feel outrageously guilty. I was not here to unmotivate or make people feel helpless or anything like that. The law is a bit of a drab thing in a way, and it can be a bit of a downer, so to speak. But no, look, let's get excited about it. When an EIS does come out, and we're talking now about an EIS, not a review of environmental factors, the Narrabri project is a big project. It's a state significant development, and there will be a more comprehensive EIS accompanying that full-blown application. That is your opportunity as the community to actually grapple with that document. It is your opportunity to work with independent experts who are not part of that document creation, to get them on board, to help you as a community to actually have some input, to put your submissions in, to have your say. And it is a process. I know a lot of people get submission fatigue, or they might, they wonder whether their submissions really do anything. Well, look, I can tell you actually firsthand they really do. They make all the difference. You have an entrenched legislative right. It's the only one you have, and it is the time to really get your material to the decision maker and try and influence the decision makers in the best way you can. You may not, okay, and there's a staged way of looking at it. If you want the project refused, so to speak, you might not succeed. But if you want the project to be a better project, you certainly may well have an opportunity to make it a better project, to make better safeguards around it, to achieve conditions around it that provide accountability. But in the first instance, this is where you get to have your say. So I think it is really important.
Can I just ask someone in the audience to make a comment about this? Because in the Southern Highlands, we've taken the view that we have to be prepared for every eventuality. So we've spent a lot of money on a water study and all sorts of other things. And Philip Pells was intimately involved. And I just wanted Philip to talk a little bit about that quickly before I go back to the lady in the green. It's not working, Philip, the microphone.
The comment I'd make is this, is that these EISs involve millions of dollars in fees to consultants. We talked about the groundwater modelling earlier. A serious groundwater modelling is $250,000 exercise just for a start, and that's not covering any of the other things. When the Narrabri EIS hits the road, whenever it hits it in a few weeks' time, we talk about a multi-million-dollar study that's been undertaken by consultants whose lifeblood depends on those studies. And as Peter said, the object of the EIS is not to evaluate the environmental impact, it's to get the project through. That's its object. Our fatal flaw in our system is that the community then has to defend against this with no money and no time. That's right. And it's all very well to say it's the opportunity of the community to put something forward, but it's like David and Goliath, except you've taken the stone out of David's sling. And then you say, go on, fight fairly. It's not a fair system. And our system is fatally flawed until the EISs are no longer paid for by the proponent. Simple as that.
I'm not saying it's a good system, it's the only one we have. Yeah.
I'm Dr. Melissa Haswell, and I'm a member of the Doctors for the Environment Australia and also the Public Health Association of Australia. And a number of health and medical groups have highlighted the health and well-being risks that are inherent in coal seam gas mining as well. And we often call for a health impact assessment where we actually look at what the community's concerns are and put it together through a formal process rather than everybody having to do it one by one in the case of these proposals. Do you see a possibility of that ever happening, or any advice from organisations concerned about health and well-being to get that to be part of the process?
Yes, that's a really good question. My experience was that the people project managing the projects that I was involved in didn't pass to me Department of Health assessments because I was looking at the Environment Department's comments. I never saw what the Health Department said, and to this day I still have not seen it. We've put in freedom of information requests to government, and they've come back with a lot of heavily redacted pages. Possibly the Health Department's comments are in there somewhere. If you look at it's a good exercise to go and look at the licences, the environmental authorities that have been issued after the EIS process that's happened in Queensland. Because if you go and have a look at them and you search for some of those contaminants that are of health concerns, you'll find that they're probably not there in the environmental authority where they should be. That's a huge flaw, and it's really, in my mind, the public servants who have signed those licences off have really been breaking the law as far as I can see, because they haven't followed the Environment Protection Act for starters, which does require you to consider what's called the standard criteria. And in the standard criteria there's a list of aspects that people are supposed to consider before they make a decision to sign off as the delegate of the administering authority. And that just it doesn't seem to have happened, yet these licences have got signatures on the bottoms of them. Things like the precautionary principle is something they're supposed to consider under the Environment Protection Act. Intergenerational equity, ecological integrity, these are just some of them. I'm not going to read them all off to you. Just to give you an idea, the NEIS and assessment or report, the character, resilience and values of the receiving environment, the public interest, submissions made by submitters. So really, and that's one of the points that I raised with the Crime and Misconduct Commission in Queensland, that these things were signed off without very important information, and conditions that didn't cover off all those impacts that we should have been covering off on.
When projects have merit appeal rights attached to them, which a lot of these projects no longer do, they're matters often that we would get experts and raise in a court that's then reviewing a decision that perhaps hasn't focused on that as an issue. But I mean, in New South Wales they tend to refer things to the New South Wales Department of Health for comment. But yeah, I mean, there's no real entrenched requirement. So yeah, it's probably lacking.
Peter Bishop. So, question to you. You mentioned that the Santos project has been classified, I think the words you used were state significant. Mm-hmm. Could you explain, does that classification entitle the project to override authorities that might otherwise have something to say about it? Does it transfer the final arbitration to some person who is not answerable to the various authorities?
Sure. State significant development is just basically what it is major projects. It means that they're assessed by the state government, the Department of Planning, and ultimately will be approved by the Minister for Planning. But what the Minister for Planning does now is he delegates his responsibilities for project approvals or refusals to what's called the Planning Assessment Commission. So that's a body in New South Wales of independent people who are on a panel, and they are appointed to assess each project and then make a final determination about these state significant developments. So ultimately, state significant development, there's a particular special pathway for state significant developments, unlike, say, a development that's assessed by council. And ultimately, the decision maker for Narrabri, I have no doubt, is the Planning Assessment Commission.
Who pays those independent?
They're appointed through the Department of Planning. So ultimately, the minister, it's planning. New South Wales Planning and Infrastructure. Yeah.
Thank you. Nikki Shirley from Willow Tree. I've got a couple of questions. One I think relates to your question, Peter. Is the lately signed MOU from the New South Wales Government and Santos a legal document, and is it challengeable?
The MOU, I had a feeling that would come up today. Look, there's no, it's a memorandum of understanding, but it has no place in law. I mean, what we have is a strategic energy project, and that's not a legal classification. I understand that there's a subcommittee of cabinet or something that has created a policy that allows projects to be called strategic energy projects. I think the Deputy Premier was the chair of that committee, and basically that it's a policy that calls these projects these strategic energy projects. So it's nothing legal as such. The Memorandum of Understanding is an interesting document though. We did see the last time our office dealt with an MOU was one where the Planning Minister, Minister Sartor, the ex-Planning Minister, signed an MOU with a proponent saying, if you do these good things with biodiversity lands, I'll do everything I can to get your project through. Given he was the person who granted approval, clearly we had what Ian was talking to earlier about. There's a real perception of bias there. If you've got someone shaking a hand on one front with an MOU saying, I'll do everything I can. The issue, or the situation with this MOU is it makes it clear that it's discussing a time frame and it's not discussing any kind of derogation of power or process in relation to a proper assessment for the project. It's also got nothing to do with the ultimate determining authority, who is Minister Hazzard. This is a document signed between Minister Roberts and Stoner and the Santos executives. So unless there is something about this that influences the decision later in its substance, then I don't think it means anything at this point, other than what it's saying it means, that the government's committed to a timely delivery of this project.
It instructs the chief scientist.
I think we better move on.
Yeah, and I don't see any illegality with instructing people to undertake their role as such. Right. Okay. I mean, look, if you think there's a legality with it, you should probably go and see someone about it.
Can I just ask the second question? Or?
I think we better move on to someone.
It wasn't about that. It was something else.
Sorry.
Go
okay,
ahead.
very
Now
quickly.
We've got two. You're probably
and
the
it
second last.
Okay, it might be too big. When you gave us that list of legislation and processes, I was just wondering if the panel might like to say what they think would be the most important piece of legislation that we as a community should be working to change, if there was one thing we had to focus on, or is that too big?
I mean, look, it's probably worth to say, at the moment, New South Wales is currently halfway through the once-in-a-generation reform of the Planning Act. Ultimately, it's the Planning Act that these decisions are made under, the Environmental Planning and Assessment Act of 1979. We saw last year the massive attempts after a couple of years of Minister Hazzard trying to get that through the Parliament, and it hasn't succeeded. So the Planning Act of 2013, the Planning Bill of 2013 is somewhere in this building, and I don't know where. So,
Ian?
I think it's already been said from the floor, but if the process of assessment was changed so that you had a panel of accredited independent experts, and a name came out of next cab off the rank did your hydrology or whatever, and in it went. It was all removed from the proponents. I think that would go a long way to curing a lot of problems. It comes back to transparency.
I think last question from Peter.
Peter Shannon from Queensland, Dalby on the Darling Downs. I in particular would like to speak to the gentleman that asked or was giving up about the EIS process. And I really just wanted to share the importance of the public involvement relying on the Queensland experience, and I realise it might not be identical. But in some cases, the public input is the only, as well as the EIS itself, is the only information that the regulator can have regard to. So if you don't put it in there, they can't rely on it. In other cases, it's an excuse for conscience-driven regulators, such as Simone, who I can't applaud enough, to actually turn their minds to it because they are totally overwhelmed by representations from industry. And to balance that process, it's just imperative. Another situation is purely delay. With Arrow's EIS up in the Darling Downs, the volume of information that came in from the public delayed the process, and in a lot of this, delay equals improved information, improved public awareness. A lot of things hadn't been considered in the EIS process that were overwhelming for the proponent and the regulator. In particular, for instance, biosecurity for poultry and feedlots and things like piggeries, which really they had no answer to but to go back to the drawing board. And that delay was imperative in the commercial context. And also it gives others information and grounds for maybe action or lobbying or whatever. So it's that public input that is just critical, particularly in a specific area, because it's you that know Narrabri and it's you that know the local environmental and context. So if you don't give the regulator that, they've got nothing to work on. It's a little like a tennis club or something like that. You can't whinge about the committee if you do nothing about the input. And really, while we've still got it, let's celebrate the fact we're not in North Korea, and we do at least still have a voice, even if it is token, because in Queensland they're currently discussing the possibility of limiting objections to coal mines to the actual owner of the land only, not to neighbours. So it's a race to the bottom, folks, and I think we beat you by a long shot. But if that comes in, then saying nothing publicly and being involved in that process really will come back to haunt us. Thanks.
I should mention Peter Shannon is probably the expert in Queensland on land access, and so well said, and thank you. Look, I'm going to wrap this up now. We've used up our time. You could go on forever about legislative issues and legislative shortfalls. I think the issue is two-sided. It's how do we put in place a robust legislative and regulatory system that enables the right projects to get up and running efficiently and effectively and stops the dodgy ones. And then how do you, on the other side, make sure that communities and landowners are looked after. And I think it's the system, Ian, people have said it, on both panels. That's why I was upset at the last panel, because they were pinching our ground. It's about transparency, it's about information, it's about independence, and the issue we all face is, by and large, I know this is a sweeping statement, politicians and bureaucrats don't like any of those things. But I think the issue here is we would ask them, because if they embrace those concepts, I think all of our political system would be better and our bureaucracy would be better, it would be a lot fairer, and people would feel a lot better about it. While we have a system where the rules, as ICAC, if you read the third report that came out from ICAC on the coal mining industry, many of the parallels exist here. There's opaque rules, there's an ability for ministers to, let's say, make ministerial discretion or apply ministerial discretion in decision making. There's decision making inside departments that can't be audited or checked. There's meetings going on that with no minutes. There's a whole lot of nasties in there that really need to be addressed. And I think, you know, the one positive that we should take away from this is, even though we're all critical of governments, whether it's whichever side, right now there's a window of opportunity. We've got a coalition government in power, we've got ICAC investigations going on looking at both Labor and Liberal politicians. We've got a new minister in the resource and energy area who is looking pretty seriously at all this. We've got a new compliance unit there that were talking to me today about something else. They are very serious. So we have to drive through change. You cannot leave it to the politicians to drive through change. It's the community that leads change. And if we don't do it, it won't be done. And I think that's the point. And I do believe the ground is shifting, and if we keep driving forward, we will ultimately end up with a far better, more robust system. And we have to participate. We've got to go hard in a PAC meeting. We've got to put down solid scientifically based evidence if we can, and we've got to think about doing it earlier, so we're not scrambling in the last 6 weeks to respond to a document. We're doing our own work, we're getting it in, we're tabling that water study, we're hitting the legislators with the financial analysis of the project right up front and saying, match that, mining company, tell me where I'm wrong, rather than us responding. So I just like to say thank you to all the panellists. I think that was a great session. Unfortunately, you know, we could go on all day and we only really scratched the surface, but I think you'll understand that there's a myriad of issues here. I think the organisers of this, Hugh and Warwick, it's been a wonderful experience. Hopefully tonight more of these things will come out, and thank you all for attending.
Thank you very much, Peter, and certainly a particularly stimulating session. We're going to take a break for about an hour. Whilst you just wander off out, I'm not afraid to fly dangerously. There's been some suspicion of who and whom we invited to this. The whole population of New South Wales could have come if they'd wanted. There was one particular body of people that we specifically made written invitations to. They all reside in this building. We did not exclude anybody. I'll see you in 60 minutes.